You'll have to excuse me. I have COVID here. Justice Minister Schweitzer introduced legislation on Thursday in which Alberta would adopt a new impaired driving enforcement regime. It would essentially decriminalize impaired driving for first-time offenders and create administrative penalties instead. Similar rules have been in place in British Columbia since 2010. The Justice Minister claims that these rules have reduced the rate of impaired driving incidents by 36% and the number of deaths by 54%. This change in enforcement is significant. It hasn't received much scrutiny by either the public or the government. I've been a criminal defense lawyer in Alberta for 20 years, and an essential part of my role in the justice system is to try and keep the enforcement of law in Alberta fair and transparent. It is possible that the Justice Minister has been badly advised because the implicit contention in his remarks is that the Alberta system doesn't work. The BC system works better, so we're going to move to that. However, the BC statistics justifying the change are very similar to the Alberta statistics over the same time period. Since BC's performance over the past 10 years is very similar to Alberta's performance over the same time period, why are we taking away the Alberta citizens' right to a trial? As we'll show below, the Alberta system has worked better than the BC system over the past 17 years. We'll also show that the data used to evaluate the BC system is unreliable. All the statistics cited in this video have been extensively researched and sourced from government databases, primarily Statistics Canada. Links to the research papers are in the description of this video. I encourage anyone with any questions to contact me and I'll be happy to discuss these findings. Where does the number of impaired driving incidents reduction come from? It appears to come from Statistics Canada, which collects and reports data on impaired driving incidents. As Mark Twain said, there are lies, damned lies, and statistics. This is one of those circumstances. If you look at impaired driving incidents per capita over the last 17 years instead of the past 8 years, a very different picture emerges. In British Columbia, between 2009 and 2017, there was a 36% decrease in impaired driving incidents. In Alberta, between 2009 and 2017, there was a 32% decrease in impaired driving incidents. Between 2000 and 2017, using Statistics Canada per capita data, British Columbia impaired driving incidents went from 232 per 100,000 to 226 per 100,000, which is a 3% decrease over the past 17 years. In Alberta, between 2000 and 2017, using the exact same Statistics Canada data, impaired driving incidents went from 396 per 100,000 to 275 per 100,000, which is a 31% decrease over the past 17 years. Using a 17-year time frame, Alberta has reduced impaired driving incidents by almost a third, whereas BC has managed 3%. Which law enforcement model is better? BC claims to have reduced alcohol-related fatal accident deaths by 54% in the past decade. This number originates from police reports from the various law enforcement agents in British Columbia and is based entirely upon the opinion of the officer on the scene as to whether or not alcohol was involved. It is not based on any testing, such as blood alcohol testing by the coroner, and also includes pedestrians and cyclists. In the BC system, if a drunk pedestrian is hit by a sober motorist and killed, it would be included in these statistics. I think we can agree that that isn't impaired driving. BC does not clearly track impaired drivers involved in fatal accidents, whereas Alberta does. Alberta's fatal accidents and those from the BC interior are largely identical because the driving profile is similar. Speed is the single largest factor in whether or not an accident will be fatal. Alberta has many more high-speed vehicle accidents than British Columbia, probably due to lots of driving on rural highways. People who drive in the urban lower mainland of British Columbia tend not to get into high-speed collisions. The 54% reduction in alcohol-related deaths cannot be attributed solely to the BC program. Fatalities in all car accidents in the same time period are down on average 28% Canada-wide. This 28% reduction in fatalities is due to improvements in vehicle safety. Airbags, seatbelts, better tires, better brakes, collision avoidance systems, better suspensions, and more stringent vehicle registration requirements all save lives, including those of impaired drivers. It's impossible to double-check the BC number as they stopped reporting their data in 2010. The Traffic Injury Research Foundation is a non-profit organization funded by Transport Canada and the vehicle manufacturers, and it collects collision and road safety data from the provinces, normalizes it, analyzes it, and then makes meaningful comparisons from province to province. BC stopped supplying data to TURF in 2010. Why would they do that? The BC Department of Justice data, which shows the 54% reduction, does not agree with the BC Coroner's data, which shows a higher number of alcohol-related deaths in vehicle accidents during the same time period. Now is not the time to be changing impaired driving enforcement. The BC government has run roadside surveys for driver impairment for the past 20 years. A survey was run in 2010 and 2012 and 2018. The results of the 2018 survey are interesting. Between 2010 and 2018, cannabis use by BC drivers increased by 82%. That was before the legalization of marijuana occurred in 2018. That means that the survey results also show that 1 out of 12 drivers in British Columbia had drugs in their system. 1/4 of all drivers refused to participate. One wonders what they had in their system. One reason suggested for the change is court delay. However, in so doing, they're taking away the right of the Alberta citizen to have a trial and going to an administrative penalty to reduce the legal backlog in the courts. The unspoken little secret of the criminal courts is that there isn't enough court time to have trials for all accused persons. There never has been enough time. 9 out of 10 offenders plead guilty. Virtually all of these resolutions are the result of negotiation between the Crown and the accused person, with or without a defense lawyer. If every person who was charged with an offense, any offense, insisted on a trial, the system would grind to a halt in months. The value of free time in the criminal court is that it allows you to try cases in an expeditious fashion, which is to everyone's benefit. If you aren't using court time to try criminal cases, you don't need criminal courts at all. Free court time has value to society only if you use it. Will there be any financial savings from this? I don't know. I don't get to see the government books. The justice system has 2 major expenses: courthouses and staff. So unless the government plans on closing courthouses and reducing staff by not replacing judges and clerks, reducing the number of police and prosecutors, I don't see where there'll be any savings. The government states that they will not be reducing staff or court time. The overview of the legislation states that it will free up more than 30,000 hours of police time, ensuring the police are on the streets protecting Albertans and communities. That's a direct quotation. In 2018, the last year Statistics Canada collected this information, Alberta had 7,884 police officers. Assuming they all worked a 1,500-hour work year, that is 11,826,000 hours of police officer time in Alberta a year. The proposed time saving of 30,000 hours is a 0.24% of all police officer work hours in the province. Put another way, that is a saving of 4 hours per officer per year. If a 0.24% saving of police officers' hours will make a difference, we are in an enormous amount of trouble. The overview of the legislation states that 1,200 complex, full, or multi-day trials will be eliminated. I don't know what they're talking about. The standard booking time for an impaired driving trial has been 300 minutes for years. Eliminating 1,200 impaired driving trials will save 6,000 hours of court time across the entire province at current booking estimates. COVID-19 and the cancellation of months of court time has forced the prosecutors, both provincial and federal, to make hard decisions about what is and what isn't going to be prosecuted. This decision-making process is an essential part of the function of the prosecutors and always has been. One of the reasons for more impaired driving trials is that several years ago the prosecutors were ordered to not resolve impaired driving matters to anything other than a guilty plea. Instead of resolving borderline investigations by illicit or included offense other than impaired driving, now the Crown prosecutors are stopping the prosecution entirely. This makes little sense. The refusal to negotiate settlement of impaired driving files is an internal policy of the Crown's office. It has already been changed due to COVID. Simply extend those changes to when and if regular law enforcement returns. The Crown controls what is prosecuted. As a defense lawyer who has been in the criminal courts for 20 years, and represented hundreds of people on impaired driving charges, I have observed it over and over. The only thing that people charged criminally with impaired driving care about is not getting convicted of a criminal offense. The license suspension, the fine, the vehicle impoundment, none of that is a deterrent. But the criminal conviction is. An administrative punishment is not an effective deterrent if drunk drivers aren't being deterred by existing criminal punishments. There is a philosophical problem with punishing people without giving them their day in court. I firmly believe that most of the police in Canada are decent and honest. However, their actions are reviewed by judges in public courts. It's an essential component in keeping the police honest. In the current Alberta system, the decision whether a person committed an offence is made by a third party, an independent and impartial judge. The BC model puts the decisions to punish in the hands of a police officer. In other words, if the police officer thinks you're guilty, and then you have to convince another civil servant who isn't a judge that you aren't guilty. The decision to punish an impaired driver, losing his license for a year, getting his vehicle impounded, a sizable fine, all of this is being moved from an open public courtroom to the side of the highway at 3 a.m. This sounds a lot more like the Soviet Union than Alberta, bringing the unlimited power of the state against the limited power of the individual is wrong. Ultimately, the government has to make hard decisions about what does and doesn't get prosecuted. Government resources are finite. BC is the only jurisdiction in North America that has decriminalized impaired driving, even partially. They stopped reporting their data the same year that they went to a new model. The BC model of impaired driving enforcement is not better than the Alberta model of impaired driving enforcement. Over the past 17 years, Alberta has seen a 31% decrease, whereas BC has produced a 3% decrease over the same time period. It would make sense to delay implementation of the changes until after the COVID crisis has passed and we can get some sense of what is actually happening out there on the roads. This is a highly complex question that hasn't been properly analyzed. How can anyone say what is actually going on or if it works?